If a law firm is going to use AI well, it needs more than enthusiasm. It needs rules that protect confidentiality, support good judgment, and hold up over time. So far, we've covered the traffic light system, the approved tools list, and human oversight. In this final video, we're finishing with data input rules and documentation and training. These are the policies that help firms manage risk, not just today, but over time as tools, workflows, and expectations keep changing. So let's start with policy number 4, data input rules. Even if your firm chooses the right AI tools, you still have a problem if people are entering the wrong information into the wrong system. That's where many firms get exposed. The ABA has made clear that lawyers need to understand the benefits and risks of the technologies they use. And that includes understanding how a tool handles the information entered into it. So strong firms usually build data input rules around 3 basic ideas. First, confidential client information should not be entered into public or unapproved AI tools. Second, when possible, inputs should be minimized or anonymized. If you can remove names, identifying facts, or sensitive details and still get useful assistance, then do it. Third, if a task truly requires real client information, it should be done only in tools the firm has approved for that level of security and confidentiality. That means looking for things like encryption, access controls, vendor commitments, and data handling terms that match the firm's obligations. These rules protect clients and they protect the firm. Because the issue is not just efficiency, it's whether the firm can defend how it used AI if those choices are ever questioned. Now let's talk about policy 5, documentation and training. A policy only works if people know it exists, understand it, and follow it consistently. That means firms need to document AI use in a practical way. What tool was used? What kind of task was it used for? Who reviewed the work? And then, of course, what happened if something went wrong? That kind of record keeping helps firms spot patterns and strengthen internal controls, and then respond more effectively when issues come up. And training matters just as much. Not one training at onboarding, ongoing training, because AI tools change quickly. Risks change, features change, terms change. And a policy that made sense 6 months ago may need updates today. A practical approach is to review the policy regularly and update it when the firm's tools, workflows, or regulatory environment change. And good training is not just about rules, it's about helping people understand why the rules exist. When attorneys and staff understand that a careless prompt can create confidentiality, accuracy, or client trust problems, they use these tools very differently. So here's the full picture across all 3 of the last videos. Policy 1. A traffic light system to classify AI use by risk. Policy 2, an approved tools list so the firm knows what can be used. Policy 3, human oversight for substantive legal work. Policy 4, data input rules to protect confidential information. Policy 5, documentation and training so the policy actually works in practice. None of this requires panic, but it does require that you are intentional. Law firms do not need to avoid AI. They need to govern it. And the firms that do that well will be in a much better position to use AI confidently, responsibly, and competitively. If this series was helpful, please follow, connect, subscribe. There's a lot more coming on how law firms can grow with AI while staying aligned with ethics, confidentiality, and client trust.